Hello and welcome everyone to this Jones Day webinar on trade secrets protection and enforcement in Europe. We have a cross-EU panel assembled for our discussion today. My name is Indra Bhattacharya. I'm part of the London IP team and I practice in a range of IP disputes, including trade secret litigation. I'm joined today by Thomas Bouvet from our Paris office, Christian Paul from our Munich office, and Marta Delgado from our Madrid office. We all work closely together. Indeed, Thomas and I are currently working on a trade secret case at the moment, which has cross-border elements. And we're going to try and offer a bit of that same cross-EU perspective during the course of this presentation today. And we're going to show you, hopefully, some war stories. We hope you find the discussion useful. A small bit of housekeeping, I think, before we kick off. As Becky mentioned, everyone other than the speakers' mics are currently turned off. But we do want to get to your questions. So please use the chat function on your screen to submit questions, and we'll try and deal with as many of them as we can at the end of the presentation. I should also like to let you know that we will share a copy of the slides to all the participants after the presentation as well. In terms of our agenda, we have reserved around sort of 45 to 50 minutes for the main discussion, and as I said, a few minutes at the end to address some of the questions. Thomas and Christian will kick us off with initially setting the broader context for the discussion about why is trade secrets important, and then Marta and I will give a bit of a brief overview about what the Trade Secrets Directive is and how it's changed the law across Europe, and then we're going to talk through some key concepts like what is reasonable measures and how the courts judge that, and we're going to talk a little bit about how trade secrets dispute litigation differs across the number of different jurisdictions that we all practice in. And finally, we'll finish off with a bit of a case study to hopefully bring some of these issues together. So with that, I will ask now Thomas to now address the importance of trade secrets in a business in terms of its IP strategy.
Thank you, Indra. Trade secret law provides an opportunity to protect information against illegal acquisition, use, and disclosure. The type of information that can be protected by trade secret is extremely broad. It covers technical information, such as the formulation or design of a product, its manufacturing process, selection of raw materials or suppliers, the source code or algorithm of software, or the collection of information, whether structured or not, in databases, including information that can be used to feed AI devices. It also covers commercial and financial information, such as R&D plans, ongoing project, or purely financial information. Trade secret is therefore an interesting addition to ordinary IP rights. Patent coverage does not always provide exclusivity over all the scope of the relevant technology. Patents may not be filed at early stages of research because additional development need to be performed. Copyright or design protection often does not always offer the appropriate protection. Trade secrets, however, are sometimes difficult to define and to scope out, and are thus sometimes neglected. Know-how and process information is often not well documented. Information can be generated and built on over many years, and trade secrets are sometimes difficult to distinguish from the general stock information and knowledge of employees. However, those difficulties can be overcome by companies taking the decision to actually protect their trade secret. The purpose of today's webinar is to convince you of the great opportunity offered by trade secret protection and to give you practical tips to enable you to benefit from this protection and to make the trade secrets an asset of your company.
Why are we doing this seminar now, and why do we have such a great number of attendees listening in today? I think this is because we all feel that something has changed. We see new challenges with the COVID-19 pandemic, which has led to a significant increase in the number of employees working remotely. We see the new norm where employees interact with other employees through indirect means, email, file sharing, etc., using new tools, new measures of collaboration. And we also see a stage of increased business uncertainty, which naturally leads to more employee mobility. So all these factors of new technology, remote working, and the uncertainty on the business side combine with recent changes to the legal landscape in Europe, which are significant. And this leads to a situation which some people even call a perfect storm. I would say it's definitely at least a stage of significantly elevated risk. So let's look maybe at the mechanics and key functions of the law in Europe to give you a better guidance on that. Indra?
Things to appreciate. One of the important things to appreciate from the outset is that before the directive, there was actually very little harmonization across EU when it came to trade secret issue. Each country had their own sort of own traditions and history about how trade secret rights was protected and enforced. So, for instance, in the UK, which has had a long history of trade secret law under the law of confidence, which forms part of the equitable jurisdiction of the court, whereas in continental countries, this was part of the trade secret protection offered under the law of unfair competition. This is where I think the directive really came into effect. The directive came into effect in around sort of mid-2018, and it's actually a fairly short document, but it does a couple of very important things. Firstly, it harmonizes the definition of trade secrets, and Marta's going to talk a little bit more about how that's changed the legal landscape. Secondly, it provides for minimum standards of protection of trade secrets. It's important to stop here, I think, briefly and just mention that these are minimum standards of protection, and member states are free to actually implement higher standards than those provided under the directive. And in fact, a number of member states actually have done so. The trade secrets also, the directive also provides for harmonized remedies in relation to misuse and misappropriation of trade secrets, and introduces new rules regarding the disclosure of trade secrets during legal proceedings. We have listed on this slide a couple of examples of how the laws in the different countries have changed. We don't propose to go through that as part of this right now. I think suffice to say, for our present purposes, is that the changes range from somewhere like the UK and France, where the implementing legislation effectively reiterates the existing provisions of the law, to somewhere like Germany, where there's been actually a whole-scale revision of the law. I think one of the more important things that the directive also does is to set an overall framework for legal assessment on what constitutes trade secret breach. And this is what Marta will run through now.
Thank you, Indra, and hi, everyone. Well, trade secrets are one of the most commonly used forms of protection of intellectual creation by businesses, and yet they are the least protected by the prior legal framework. So it was, when the directive was approved, it was a very, very welcome piece of legislation. The directive brings, just to summarize it very quickly after the introduction done by Indra, provides three big blocks that we need to go through very quickly now. First, about the definition of trade secret. What is a trade secret? Not everything, not all types of information can amount to a trade secret. And so the three questions to be asked according to the directive are the following. First, is the information generally known or readily accessible? Second, does the information have commercial value? Because it is a secret. If it has no commercial value, it really doesn't matter as a trade secret. And third, has the information been subject to reasonable steps to keep it secret? And this is a very relevant point, and one that we will discuss a little later more in depth, because it is a real hurdle in procedures for the protection of trade secrets in the different jurisdictions, as we will see. The second step to be taken into account, the second block of ideas for you to retain today about the general harmonization done by the directive is based on a very relevant notion, which is not all secrets deserve the protection of exclusivity. There are some forms of acquiring a trade secret that can be lawful. And so the directive provides those lawful forms, such as the independent creation or the independent obtention of the trade secret, the reverse engineering unless it is expressly prohibited in the context of a relationship between two parties, honest commercial practices, etc. As opposed to those lawful ways to obtain the trade secret, there are, of course, very clearly identified and lawful ways to use or access or disclose trade secrets that are also provided in a harmonized way in the directive. And going to the third block, what the directive does also for the benefit of all companies, employers, employees, and the courts themselves is to create a set of remedies that will be available as a tool for all, such as preliminary injunctions and other interim remedies, final injunctions, damages, and corrective measures. So with that, we can go and discuss a little bit more about the reasonable measures, which I said before is one of the most key elements in the protection of trade secrets. Thomas, if you want to go ahead.
Exactly. Building on what Marta has just mentioned, one of the main takeaway message that you must get from this webinar, if you are not already aware of that, is that trade secret protection is available only to those who have taken step to set up and actually implement policies and procedure to identify and to keep the trade secrets secret. It is important to do it right from the beginning. A policy cannot be set up to address a violation that has already occurred, and the policy must meet the standards required by the law and by the courts globally. Must have include confidential information in each employee employment contract and also in the employee handbooks. All agreements with partners must also include confidentiality obligations, prohibition of reverse engineering, and post-termination obligations. Must have also include robust NDAs template and employees educated to have such NDAs signed and ahead of any disclosure. Key documents and support must be marked at least as confidential. Access to sensitive information must be limited, both electronically and physically, and this requires involving IT resources. First, to restrict electronic access to a category of authorized persons, to monitor the access, copy and transfer of confidential files, and to generate alerts when unusual or suspicious events occur, and also to prevent cyber attacks, including doing regular intrusion tests. Setting up ad hoc trade secret policies can even provide a better protection, as they generally include explicit identification of trade secrets with an assessment of their relative importance, and as they also include increasing control and monitoring of the access of files containing such information. Such policies and procedure also trigger considering embedding trade secret protection in the design of the product or in the organization of its manufacture or of its exploitation. All of those policies must be well documented in order first to educate the employees and partners, but also to prepare proof that such policies have been set up because courts will request such evidence. Finally, there's a need to remind regularly those policies to every employee, and also to revisit the identification of trade secrets on a regular basis. From this, Indra will comment on additional measures or more specific measures regarding remote working.
Thanks, Thomas. I think some of the issues that Thomas was referring to in the earlier slide are particularly important now in the context where a significant part of the workforce is working remotely. The data collected by a number of forensic IT companies show that there's been a marked increase in cybercrime as well as data phishing, and they're effectively all just trying to exploit the vulnerabilities of the IT systems of people working from home, which is obviously not as sophisticated as the ones that are in the office. We have listed on this slide a number of initiatives that can be taken by companies to address some of the risks. It's important to sort of say at the outset that these are all these are general principles, and I think the specific actions that need to be taken will depend very much on the nature of the organization. I wanted to highlight, I guess, three core sort of conceptual things. Firstly, when it comes to remote working, it becomes more important than ever to make sure that sensitive information is appropriately categorized and access to particular sensitive information is limited, such that the dissemination of that information is properly controlled. I think it's also important to have in place quite robust security measures. Most companies have tried to bring in specialist IT resources to deal with remote working. Things like VPN systems can be quite helpful in stopping and or sort of minimizing the effect of data hacks. Other things that are quite important are things like access to unsecured public networks and own device uses. In our experience, some of the most egregious trade secret breaches happen through these portals themselves. And so this is a good time, I think, to reassess some of these policies about how access to both public networks and own devices should be managed. And I think the overarching comment from Thomas before is around education and training is doubly more so important when it comes to remote working. We routinely run trainings with in-house counsel on trade secrets issues, and if trade secret is a key concern for your company and remote working is going to be a feature, as seems likely for many organizations, I think this is a good place, this is a good time to put in place specific training to make people aware of some of these requirements. I think some of these points can also help with issues of departing employees, where we see a number of the breaches and the dispute arise from. And Christian will talk a little bit about that now.
It's Marta. I haven't changed it to Christian. But before talking about the departing employees, we wanted to discuss a little bit about the common issues with ex-employees. So the directive itself acknowledges that trade secrets are a competitive advantage to companies, and that is, of course, evident to employees of a company who will have sometimes a tendency to want to continue to use those trade secrets elsewhere once they leave the company. So knowing what are the most common issues with ex-employees can be very helpful for companies, because it will allow them to prevent those issues from taking place, or it can allow them to identify them quickly and that way minimize the potential impact that the end-use disclosure or in any way infringement of the trade secret can have on the company's activity. So what are those common issues? And in my experience, what I have heard quite often is that employees, of course not all of them, but some employees who leave with information that belongs to the company feel that they have some kind of ownership of that information because they have been using it for a long time, and in a way they believe that it is in their head, and so as an excuse to having used it unlawfully afterwards, I have heard, it's in my head, I cannot erase that knowledge from my head. Of course, within the concept of trade secret, we shouldn't include common knowledge or skills or trivial knowledge or experience, but actual trade secrets, as I mentioned before, under the concept of the directive. And so that is something to be very clear about in the training to employees. And going again back to the most common issues that we have seen, they would be the following: the access or acquisition or copy of trade secrets without authorization, as you see on the screen, the knowingly disclosure of trade secrets to unauthorized third parties, or the use of trade secrets for unlawful purposes, for example, and this is very, very typical, to set up or advance a competing business. As we say, this is a real asset for a new company, and so having trade secrets that are of value can be very important for a new business and to advance in the market. But very typically, they are also used in the new company to make progress in that company and acquire a better relationship with the new employer. Sometimes they are used for their own commercial gain, like to sell or attempt to patent or license the trade secret and obtain some kind of economic advantage, or finally to harm the trade secret holder. So sometimes ex-employees have a grudge and would like to simply do harm to their former employer, and by disclosing the secret or using it, they know it will harm them greatly. Finally, another common issue with employees, and one that must be on every company's mind, is not the fact that the employee is leaving the company, but when a company is hiring a new employee, because the information that that employee brings can be just as harmful. And Christian will now talk to you about that. Thanks, Christian.
Right, thanks, Marta. So let's take a look at what companies actually can do in practice. And I think most companies are well aware of and also have procedures in place to deal with departing employees. And that, of course, is indeed very important, because maybe you don't need to basically look at everyone in the same level of detail, but a well-managed company should assess the risk level of trade secret infringement by certain employees. Clearly, there will be employees that are more exposed to trade secrets and should warrant a closer look. Keeping in mind that once the notice of termination has already been given, that may actually be too late to really to take a close look and take measures. It's important to have security measures in place that prevent copying and unauthorized sharing of information also before the time that an employee actually gives notice. That should be part of the general measures that we addressed before, also intertwined with cybersecurity measures within the company. It is, in any event, very important to set up an exit interview, because simply to make clear to the employee what the rules are. And many employees may not actually be bent on actually infringing rights. As Marta mentioned before, there may be simply, we are looking at a level of non-awareness of what is actually allowed and what not. That can be clarified in an exit interview, where it can also be checked to what extent the person has been exposed to trade secrets, whether they are still in possession of data carriers, papers, etc. All these checklists that should be gone through as a matter of best practice. It's, however, very important that at least for the crucial holders of trade secrets, that the activity of the employee is monitored after departure to the extent possible. Because only if you follow up, only if you really are interested in what actually is happening there, you can get the prima facie evidence that may actually be needed to stop any infringement of trade secrets that may be going on. Now, that is the part on the departing employee. It's likewise important, and some companies miss that, to do this for arriving employees as well. And that is for two reasons. The first reason, if you properly inform the employee at the time when he joins the company what the rules are, and also make clear that the company has a trade secret policy that will be followed and the infringements are not tolerated, that serves two purposes. First, of course, to the lawful employee, you increase the level of awareness. You make it easier for them to comply with the rules. And for those that may be more risk takers and think they can just do whatever they like with the things they get, it's a clear message to discourage them from actually even thinking about potential trade secret infringing acts. So as a prevention measure, it's also very important. It serves another important purpose, though, and that is to avoid contamination. And we believe that the contamination risk is something that is often underestimated, and Thomas will explain in more detail why it's worth looking at that.
Thank you. Yes, contamination refers to any situation where a company's activity is negatively impacted because it holds unnecessarily trade secrets belonging to another company. Such contamination is unnecessary when the information received under confidentiality and non-use obligation either is already known from the party receiving it, or could have been developed independently without excessive efforts, or was simply not needed at the time. Contamination can arise in a number of situations that some of them being mentioned on your screen. For example, employees working on a project holding third-party trade secrets coming, for example, from their previous employer, or NDAs signed in relation to M&A deals which eventually do not follow through. Companies must learn how to avoid those risks of contamination. And they must also learn how to operate when such a contamination has occurred under specific protocols intended to, in particular, keep clear evidence of every step of the independent development of a project going on when contamination has occurred. With that, Indra, if you can maybe bring us through the jurisdiction-specific procedures.
Yeah, thanks, Thomas. So I think one of the first things people need to decide when deciding to take an action in relation to a trade secret breach in Europe is the jurisdictions in which that action needs to be taken. Now, parties don't have complete freedom to issue anywhere. I mean, you need to show some kind of connection with the jurisdiction. For instance, you need to look at where, in fact, the original breach happened, where some of the damages have been suffered. But in our experience, given the multinational businesses and the EU single market, it's usually rare that trade secret disputes are just limited to just one jurisdiction in Europe, and they often have a cross-border element. So I think this is where the procedural aspects of the different member states come into being. We talked a little bit before about the harmonization of the substantive law in relation to trade secrets, but it's important to appreciate that there are still significant differences between the different member states when it comes to procedure. When it comes to the UK, there's probably a few things to mention here. Firstly, the UK has a relatively fast and flexible litigation procedure, and the High Court in particular has been willing to streamline cases and tailor the procedure to suit the facts of an individual case. The judges in this jurisdiction are also increasingly actively managing the cases, which means cases tend to come to trial relatively quickly compared to some of the other jurisdictions. One of the often difficulties claimants face when prosecuting trade secret disputes is getting documentary evidence from the other party. I think this is where the UK jurisdiction offers a unique advantage by way of disclosure, which is similar to US discovery, although the ambit is more limited. UK procedure also recognizes a formal procedure for conducting experiments, and these can often be quite important in technically sophisticated areas like pharmaceuticals. I think the existence of disclosure, experiments, the fact that we have technical judges and cross-examination of witnesses at trial means that whilst UK litigation can be expensive, at the end there is a thorough investigation of the underlying issues, and that can often help with disputes that have a cross-border element in jurisdictions that don't have some of these features. It's also important, however, to understand that the UK court will require the claimant to specifically identify exactly what's been taken and why we say it is confidential. And it's important, therefore, to think about these things quite carefully and engage the business early on before making a decision to issue proceedings.
In France, trade secret litigation is not handled by specialized courts, but by ordinary civil or commercial courts, thus resulting in relatively long proceedings. We're speaking of an average of at least 2 years before trial in an action on the merits. Evidence collection is also governed by ordinary rules of civil procedure. When evidence is located in France, search and seizure procedure, that are also referred to as done red, are extremely helpful and can be very powerful. If evidence is not located in France, however, the gathering of evidence can be more difficult as we have no disclosure procedure in France. In such situations, court-appointed expert proceedings can be useful. Obtaining evidence from other countries is also something to consider and very helpful. And finally, criminal proceedings can also be considered. Last point, and that results from the changes that the implementation that has been made in France. There are now very clear and efficient measures to protect trade secrets during the litigation process with the possibility of having confidentiality clauses and redacted judgment that was not possible before the implementation of the directive. Christian.
Right. As regards German proceedings are known to be very efficient and rather short in comparison, and that is because they are what we call front-loaded proceedings. It means the plaintiff has to bring all the evidence, and ideally right from the start. So that means, of course, that the plaintiff has to have the evidence, and that is the big challenge in trade secret cases. It's very important to have a good case if you really want to go through the proceedings quickly. Now, in particular in trade secret cases, the means to gather evidence are essential, and just like in France, Germany has the concept of dawn raids, which indeed means basically raiding the competitor's facility or documents when it comes to being in a lack of evidence that is actually needed. What you need to show is a prima facie case that there may be an infringement, and then you can get a court order that allows you to search the premises and get the evidence that is needed. It's in particular useful for software questions, for example, but also for all other technical, pharmaceutical, etc. Measures where you suspect and have reasonable evidence to believe that the trade secrets are used, for example, in the R&D department of a competitor behind closed and locked doors. So what else should be considered when litigating in Germany? As Indra mentioned in the beginning, the new regime that we have here in Germany is a total recast of the previous one. So many questions have not really been tested before the courts yet. And that, of course, offers risks, but also opportunities. Because depending on the situation, you may try to test the boundaries and run cases that you feel you have a right to, even if there's no established case law yet. What remains, and that is something that cannot be stressed enough, it is very, very important to have the basic requirement, at least in place, and that is get your trade secrets marked and documented. Because in particular with the front-loaded proceedings in Germany, it is absolutely important and crucial to convince a judge right from the beginning that whatever he's looking at is indeed something that is confidential and results from your company and not from someone else. So that is a big must for actually successfully litigating in German proceedings. Marta?
Thanks, Christian. Well, lots of the things that you have said, Christian, about the German proceeding actually apply to the Spanish one, except for the fact that in Spain we do have some experience with the protection of trade secrets by the business courts. And I'll go in the order of the slides. but I'll go to there in a moment. In Spain, proceedings may take from 1 to 2 years, depending on whether there are expert reports, whether there is a counterclaim, and whether other procedural things are argued by the parties. But in the best case scenario, you can have a decision in 1 year, 1 year and a half, which is not terribly bad, I would say. The competence over trade secret matters is assigned to business courts. These are not really specialized on trade secret protection as such. They handle a number of different things, including IP rights, including competition law, including unfair competition law, and including bankruptcy. So they have a very wide knowledge. But the good thing and the good news about this is that in Spain, there has been a specific national protection of trade secrets through the unfair competition law, which has traditionally provided that protection in Article 13, basically to protect the trade secrets of companies against other companies stealing them, using them, disclosing them, with or without the help of former employees or of current employees of the company. You can never discard that possibility. And so that is very positive in the sense that we already had a very similar definition of what trade secret was to the one that has been approved by further to the directive in the new law. And second, there had already been a body of discussion of jurisprudence and case law discussing a number of things regarding the protection of trade secrets, including on the matter of reasonable measures of protection, which are one of the most difficult aspects of the protection of trade secrets. So the final comment made by Christian cannot be made too many times. If a company wants the protection of their trade secrets, they need to have documented that trade secret. They need to have thoroughly gone through it over time. So it's not enough for you to document the formula of your paint 20 years ago, and then with time you make little changes which are not documented every time you make them, and then when you go to court and you apply the 20-year-old document, it might not be enough. So there needs to be a very thorough and updated practice of documenting the trade secret, but not only the trade secret, but also the measures that the company is constantly taking to protect those trade secrets. So this is burdensome, and you might forget about that unless you establish very clear procedures, but it is of the utmost importance to do it if you want to really have an asset that you can protect before a court. And actually, in the Spanish procedure, that is the biggest hurdle, followed by how you establish violation. But for that, you've got a number of different tools with the assistance of the court, very similar to the ones that exist in other European Union member states. And then finally, the moral harm that courts are able to consider when analyzing the damage is something that has been specifically provided in the trade secret law. And it is a very interesting addition that I think deserves a special comment. So that's for Spain, and I think we can now talk about remedies and relief. Indra.
Thanks, Marta. So I guess a few words on remedies. As Marta mentioned just before, these can vary quite considerably, between the jurisdictions. For instance, in the UK, we don't really have a procedure to get compensation for moral harm in the course of trade secret breaches. But there are a number of principles that I think are generally applicable. So when the breach is initially discovered, it will be obviously quite important for the company to try and put a stop to the offending activity, prevent further dissemination of the relevant information, and this is where provisional measures really come into effect. These will include everything from preliminary injunctions, protection orders, search and seizure orders, in order in order to protect the destruction of evidence. I think the general point to make about provisional measures is that the courts are very keen to ensure that these are proportionate and they are reasonable, and so therefore there is a high level of proof that is usually required in order to get these types of relief. And the court will also, in these situations, do a balancing act between the interests of the claimant as well as the defendant to make sure that these are not unnecessarily onerous on either party. Injunctive relief is also obviously quite an important part in trade secrets cases. Courts, I think, across Europe have fairly wide discretionary powers when it comes to deciding what kind of injunctive relief they will grant. From the claimant's perspective, they will obviously want this injunction to be as broad as possible. And so, for instance, if there is a finding of liability in relation to, say, a copycat product, clearly this would need to be captured. But I think things start to get a bit tricky once injunctive relief is couched in more broader terms. For instance, where there is not just the product that has been copied directly, but where information is used as a starting point in order to do further development. And we'll come to see how this plays out in the context of the case study that we'll discuss shortly. Damages and financial compensation are also another feature of the remedies that will be important here. Again, courts have fairly wide discretion. They can grant everything from a lump sum payment to a reasonable royalty, and it will all depend on the facts of the case. In certain jurisdictions, you can also choose between the losses suffered by the claimant or the profits realized by the infringer. And depending on the nature of the business, it may work out, one is better than the other. So again, this is something to think about quite early on. We have a case at the moment here in the UK where we are going through the process of trying to just put a value on what has actually happened as a result of the trade secret breach. It's turned out that the competitor in this instance was able to enter into a particular market segment that they weren't in before this misuse of confidential information happened. And so we are working with the senior levels of the business at the moment to try and understand how this breaks down across Europe, the extent to which the market share changed as a result of the competitor coming onto the market, the extent to which some of the losses would have been suffered in any event. These are issues that I think it's important to have in place, not just lawyers, but also accountancy and economist input. In Jones Day, we've got an in-house economist who is very much familiar with these kinds of concepts and work with us regularly in trying to understand the value of the claim in this way. This then sort of neatly takes us into the case study that I wanted to sort of chat through over a few minutes. The case is VESTERGAARD versus BestNet. If you've been looking at trade secrets issues across Europe over the last few years, obviously this has been something that may have come across your radar. The facts of the dispute are fairly complex, and we don't really have time to go through that in detail. I think it suffices to say that what had happened is that VESTERGAARD, the claimant here, had engaged a consultant as head of R&D to decide to basically develop and design these long-lasting insecticidal nets. The relevant trade secret in issue here was essentially a database of formulations of samples of nets. These had been generated over many years, which comprise various medicinal product formulations. And this consultant was basically responsible for overseeing this development. Then the familiar story, the consultant then leaves and joins a competitor, BestNet, and within a short period of time, BestNet has got its own insecticidal net as competing product. The facts here, this is where the facts become a bit more complicated. What had been sort of realized at the outset is that what BestNet had done was initially copied some of these formulations, but then essentially taken some of these initial work that was done by VESTERGAARD and then engaged their own development process, which was quite long and lengthy, and then basically developed their own products, which were quite different to the original VESTERGAARD formulations. it was difficult to know exactly what confidential information had been used. Parallel litigation then ensued with key ones in the UK as well as in France, and the cases came on at quite different times. The UK case came to trial before the French case. In the UK case, what the trial judge initially found was that whilst the VESTERGAARD formulations had been developed with the misuse of the VESTERGAARD information, those final products did not actually embody that confidential information itself. Instead, what the court basically said is that what BestNet had done was to essentially short-circuit that development process. The French outcome was a bit different, and this is partly because of there was additional evidence that was available in the French case that wasn't there in the UK decision. And it was more straightforward in terms of its finding, where it was held that there had been misuse across all of the different formulations. So this then led to quite different outcomes in the two different courts in France and in the UK. In terms of the remedies, in France, what had then happened was that because of the finding that these formulations had all been copied, there was a general injunction that was granted in relation to all of these formulations. It was considered in that jurisdiction that without using that trade secret, the defendant would not have been able to sort of get to the final end point, and therefore the injunction made sense. And there was also damages that were awarded, which was corresponding to the revenues that was generated by the unlawful use. The UK court went in quite a different direction, and I think that was part of the finding, the original finding, that the final BestNet product was found not to actually embody the original VESTERGAARD confidential information. The court basically said that what they had done was that because they essentially obtained a head start, rather than continue to use the VESTERGAARD confidential information, a general injunction covering the final VESTERGAARD products would be disproportionate remedy. And so the issue just came into a discussion around damages and what was appropriate. Here again, VESTERGAARD tried to convince the court that damages should be awarded in the same way it's awarded in sort of patent litigation, where it would cover any of the products that were developed. The Court of Appeal essentially rejected that argument and said that no, the proper measure of damages in this particular instance was to compensate for the accelerated entry, rather than looking at the final products that BestNet had in place. So I think there's quite a different outcome in the two different jurisdictions over over relatively sort of similar facts. And I think the reason why we wanted to sort of run through this particular case study is perhaps two reasons. Firstly, it highlights the differences in approach between two key jurisdictions. And secondly, and perhaps more importantly, is this issue of derived products that we are seeing increasingly come up over and over again in trade secrets litigation. It tends to be rare that there is a direct copycat product that is put out by a competitor where there's been trade secrets used. The more common situation, at least my experience, is that the trade secret information is used and is then used as a sort of a launching pad for a further development. And I think what the VESTERGAARD case shows is that in these situations, we need to think about relief quite carefully and quite early on to just make sure that the claimant's rights are properly protected, so that the case strategy is fashioned in a way to make sure that there is adequate compensation that is obtained, not in relation just the additional development work, but which corresponds with the whole misuse of that confidential information. I think the final topic for today is Thomas is going to talk a little bit about trade secrets audits, which can be quite valuable in identifying existing vulnerabilities.
Thank you, Indra. Yes, not all companies have already set up appropriate trade secret policies and procedure. To assist those companies, we at Jones Day regularly perform trade secret audits with a double aim. The first aim is to do a mapping of the trade secret of the company, and I often refer to that as a 3D mapping, including not only the identification of the type of trade secrets, but also their respective importance, their origin, whether they have been developed within the company or through collaboration, the way they are used, the destination, and also their sustainability. The second aim is to, and the result of that is to be able to identify how important it is and critical it is to protect those trade secrets within the company. The second purpose of this audit is to conduct critical analysis of the existing policy, including the contractual provisions that are binding the employees and the partners, the physical and IT protections that are in place, and also the existing process of identification of the trade secrets that are in place within the company. We use a questionnaire to capture the employees' perception of the existing policies, and the analysis of the answers that are provided are always very interesting and valuable. Based on the result of this audit, the company can decide to improve some aspects of its existing policy or to completely recast their policies. Finally, such audits are often accompanied by internal communication, starting with a general presentation on the importance of trade secrets, and usually ending after the audit and possibly the upgrade process with a presentation of the specific internal policy. So those audits are indeed very valuable and intended to ensure that those companies are in a position to actively protect their trade secrets and to be able to go to court and be able to fight against any legal breach of their trade secrets. With this, we have ended the first part of our webinar with those presentations, and can move to the Q&A part. Andrew Airstrup, who is an associate of our London office, who attended backstage the whole presentation and who is now on the stage, has collected all your questions and can now address them. So, Andrew.
Thanks very much, Thomas, and thank you all for joining today. The first question we've had through on the Q&A, I think I'll direct this one to Marta to begin with. The question is it more difficult to obtain experts to deal with damages in these trade secret cases?
Well, I wouldn't really think so. I think that the damages part of the directive is pretty clear and helpful, and I think that the way it has been transposed in the local jurisdictions has also been very thorough. At least in Spain, the transposition has been very good, and in the end, an expert is going to be looking at the economics, and the criteria for that are very well set in the case law, inherited in many cases from doctrine in patent law, in copyright law. And so I think there is a head start in trade secret law, in fact, for an expert to be dealing with damages.
Thank you, Marta. And Indra, did you want to add anything on that from the UK perspective?
Yeah, I mean, I think when it comes to expert assessment in relation to damages, the UK is quite adept in using expert evidence, and the courts have specialist experience in dealing with expert evidence as well. When it concerns a dispute in a particular specialist area, the court will also often appoint judges with technical expertise. So yes, I don't think that's a particular issue in the UK either.
Thanks, Indra. I think the next question I'll direct to Christian because you've been quiet for a time now. And that is, in terms of experimental testing of suspected infringing products, what if you can't gain access to one? For example, if the product is in an R&D stage?
Right. Well, that basically means we don't have anything to analyze, right? So it's, again, an evidentiary question, which, from the German perspective, poses its own and unique challenges, because as we heard, we need the evidence up front. But in such a situation, actually, that is what the dawn rates are made for. So what you would need, and that of course is necessary, you need a certain minimum of evidence. Some, at least prima facie evidence that something is going on at a competitor, that your trade secrets may have been infringed there and are used in the R&D stage for developing this product at issue. And that can be anything, right? As slim as it comes, maybe it's just someone who has seen documents with your letterhead in the R&D department of the competitor. In these cases, maybe even an affidavit by that person may be enough to convince a judge at the court to order a dawn rate to determine whether the suspected infringement actually happened or not. So summing up, I think this is indeed something, it sounds like a dawn rate case to me, if I understand the question properly. And what you need is a minimum standard of prima facie evidence. And then that might be actually a case, even if it sounds shaky at the beginning.
Thank you, Christian. And this next question, oh, sorry, Tamar, did you have something you were going to say?
Yeah, maybe I wanted to add that a particular, I mean, that's, maybe I got that from the VESTERGAARD matter, but a specific issue in trade secret matter is really that simply comparing two products is not always enough. Just because, unlike in patent matters where you have patent claims that need to be compared to a product, here in trade secret matters, sometimes the most important issue is not what does the product look like, but how did the defendant come to that formulation. And that's why it is, I think, always important, and sometimes tests are necessary to bring the prima facie evidence, but then to my experience, it's always necessary either to conduct dawn read or to have the court appoint an expert in order to understand how the defendant came to that formulation and to prove that if this formulation was used, it is because that person had access earlier on to the confidential information. So it is a difficult hurdle indeed to pass, and trade secrets are often efficient in this respect, as well as disclosure in the UK, of course.
Great, thank you, Tamar. I think we have 2 minutes left, so I think if we can just fit one more question in. And this one is actually directed, again, to you, Tamar. And that is that you mentioned the risk of contamination earlier in the slide. Could you please give a real-life example of such contamination?
Yes, well, one example that really comes to my mind is a decision that was issued last year in the US in a litigation between L'Oréal and Olaplex. And for me, that's a typical example, of the risk of contamination. What happened there is that L'Oréal was considering acquiring a US company called Olaplex, which is, I think they're in the business of hair products. And during the M&A process, they signed confidentiality undertaking in order to gain access to some confidential information in the due deal process in order to, and then in this respect, they gained access to the Olaplex technology. What happened is that the deal didn't go through, and that was it. However, sometime later, L'Oréal decided to launch a product that was actually in the same technology as the one that was used by Olaplex. And Olaplex sued L'Oréal in the US both for patent infringement but also for trade secrets infringement, explaining that L'Oréal had access during the M&A process to some of their process and certainly used it as they in order to launch their competing product. L'Oréal was actually found liable for violation of trade secrets in the US. I have absolutely no information as to what happened because we were not involved in this case, but L'Oréal explained that they had made an independent development, but and they explained that they tried to bring this evidence, but the jury trial has never been convinced by the evidence that was supplied. And to me, that's really the situation resulting from contamination, where you create a situation where the suspicion of violation is so important that I think whatever the evidence you can bring, it's easy, or at least not very difficult, to convince a jury or judges that there has been actual violation of infringement. So for me, that's really a typical example of situation of contamination that companies need to avoid as much as possible.
Thanks, Thomas. That's very interesting. So we're on the hour now, so unfortunately we don't have time for any further questions. We have received a few, and so we will follow up individually with people when it comes to that. Thank you everyone for joining our webinar session. We hope you found the discussion useful. If there are aspects that we can help you with, please don't hesitate to reach out to us individually. Thank you again.